Tonight's topic is an essential topic, particularly for employers and also for employees. Kellie, as I understand it, is going to be talking about what are the key policies that every employer should have, and what are the key aspects that they should cover, and how ought they be implemented in a way that reduces and does not increase the employer's potential liability. Ingmar is then going to speak about work health and safety generally, and more specifically drug and alcohol policies. Each of the speakers will welcome questions, but I think their preference is to have them at the end, to take them jointly, or what's your preference? Happy throughout. So Kellie would like a Q&A session. I will not be playing the role of Tony Jones. So Kellie Edwards, as some of you no doubt know, is well regarded in this area, and I think very recently has been referred to in Doyle's as one of the leading practitioners in this particular area of law. And Ingmar Taylor also is well known and regarded in this area as well, and has also very recently found his name into the Doyle's legal publication. So without further ado, can I introduce Kellie Edwards?
Well, thanks everyone for coming along. As Adam said, I'm happy to do this in a more informal way. So we are going to be talking about this from both the perspective of you as people who may be advising employers or employees, I guess, but also for those of you in the room who are part of any legal business, fairly fundamentally having good policies and procedures, particularly around bullying and discrimination, these days has a very real and important impact on our business, given the amendments to the solicitor rules and the barrister rules. So we'll be coming at this from two angles, I guess, and I'm happy to talk about it from two angles throughout. So this is what we're going to be covering today. What is the need? Where does the need for policies and procedures come from? The proper content and places you might go to get some good advice from. There's various places that on the web that talk about what should be covered in policies and procedures, so we'll talk a bit about that. And then we'll talk a bit more about the case law and where people come a cropper, if you like, where the walk doesn't actually fit the talk, and the problems with that. And I guess there's another associated issue with that. It's not just the walk not fitting the talk, but sometimes the talk hasn't kept up with the legislation. So there's a great importance in making sure that you keep up with the legislation. And there are, huge changes, every year, certainly in discrimination law. So, for example, one of the big changes in discrimination law is that the President now has a discretion to reject complaints that are more than 6 months old. So that's down from 12 months to 6 months. But more than that, there is now no automatic right of a hearing in the Federal Circuit Court or the Federal Court if the complaint is dismissed on that ground. You have to seek leave. So, as I said, important to make sure that everyone's up to date on the law and that that's also reflected in the policies and procedures. So we're going to be covering those three things in three broad areas, if you like. It's probably, we've set ourselves too great a task, but there you go. Ingmar's going to be covering the work health safety issue, and he's also going to talk a little bit, if we've got time at the end, about recent or changes to come in the domestic violence type sphere. People might be aware that there was some debate last year, an argument about it should be a minimum requirement in awards, and that's now morphed into something else. So Ingmar, if we have time, will cover that. And I'm going to be covering, in the main, the discrimination, bullying type area. So I guess a good place to start is, what is the definition of policy and what is a procedure? And I commend the dictionary to you for both of those things. But in broad terms, a policy is something that is far more general and flexible than a procedure. And I'd encourage all of you, either when thinking about this in your own business or when talking to your clients about what kind of policies and procedures they want, is they think very carefully about what they tie themselves down to in procedures. Because remember, policies and procedures can become incorporated into contracts of employment. And so you could be making a rod for your own back by creating too onerous or inflexible requirements. Indeed, in the discrimination type area, there are good reasons why you would want a very flexible approach. You wouldn't want to tie yourself down to one particular way of doing things, because each different case is quite different. Will have its own requirements that you might want to take into account rather than tying yourself down. So, having said that, and Ingmar will no doubt talk a little bit more about that, the idea of a procedure, something that is more precise and definite, is something that is in fact very useful and probably required by some sections of the Work Health and Safety Act. So it's all about what's the purpose when you think about how do you want to put these together. I guess one of the first things to say about policies and procedures is there's no express requirement of which I'm aware in any of the legislation that says employers must have a policy and procedure about X, except perhaps in some areas of the Work Health Safety Act. But what is abundantly true is that if you don't have a policy and procedure, then you're far more likely to come a cropper in relation to claims. And that's for a variety of reasons, but one of the most fundamental of which in the discrimination jurisdiction is that there are two defences that spread that are relatively similar across both state and federal jurisdictions. And the first is expressed to be taking all reasonable steps to prevent a contravention of the Act, and that's found in the Sex Discrimination Act and the Anti-Discrimination Act. And I think the Age Discrimination Act. And the other one is in terms of took reasonable precautions and exercised due diligence to avoid the conduct. So quite a different test, a little bit less case law on that one because it's more recent, and as I said, is in the Age Discrimination Act at the federal level and the Disability Discrimination Act. So if you are trying to prove that you have taken all reasonable steps, then certainly it would appear to me to be the case, and this is backed up by case law, and one of the leading cases in New South Wales is Caton and Richmond Club Limited, which is a 2003 case. That case held it's not enough to wait for a complaint before appropriate action is taken by managers and employers. An employer's obligation to prevent discrimination, harassment and victimisation doesn't begin at the time a formal complaint is made. Now, that doesn't mean that you will be unsuccessful in running that type of claim, but when, as I come to what should be the content of your policy and procedure, if you are trying to put together in your own head as an employer what is discrimination or harassment and whether the thing that's happened might fit that definition, and then what action you're going to take on the run, you're going to put yourself in a far worse position, obviously. Okay, Vance is a good example of, or one of the few examples, there's a few, but Vance is one of them, of a defence being successful under the Disability Discrimination Act. And that was a case of a woman with a sight disability who was trying to catch the train and the doors closed on her, she said, and she expressed the requirement in fairly specific terms, probably too specific and led to the downfall of the claim, but that the requirement was to enter the train carriage with quickly, and she couldn't comply with that because she took longer to find out where it was. Now, this really is a case in which the respondents' policies and procedures went a long way to proving the defence, because they were able to prove that they had in place at the time policies and procedures that in fact put the onus on the train guard to make sure that people were clear of the train doors. And he hadn't done that in this case, but the relevant train guard had received training on the policies and procedures, and so they were able to avail themselves of the defence in that case. So a really important illustration, I guess, of how policies and procedures can help you prove that kind of defence. And I guess the other thing to say, and perhaps Ingmar might talk a little bit more about this, is that certainly in unfair dismissals, if you want to sack someone because they've breached a discrimination policy or a harassment policy, if you don't, because they've engaged in discrimination or harassment, if they have signed a policy and done training and signed off on training that says that they understand that they will be bound by that policy and that they understand what it means, you're going to be in a much better position to rely on that policy when you take that kind of action. Okay, I'm going to talk just a little about bullying, and I think it's useful to do so by talking a bit about the history of how bullying came to be in the legislation. And that's for a couple of reasons. One is we're a very practical flaw. We don't come to this just as, I certainly don't come to this just as a lawyer. I used to run a management consultant before I became a barrister. And I think one of the things that can get lost in these kinds of discussions is what are the benefits for employers of introducing this kind of stuff. And certainly the referral by Parliament to the Committee of Inquiry that looked at the bullying issue prior to the introduction of the legislation, one of the things they did was they looked at Productivity Commission reports on the impact of this kind of treatment in the workplace and, of course, made recommendations based on, in part, the fact that there were substantial savings to be made if you avoid this kind of treatment in the workplace. And no doubt, anecdotally, anyone in the room would be aware that people who are being bullied, harassed or discriminated against are usually a bit less productive than other people. So in terms of the background, bullying has a relatively recent kind of ideology, history, and it really gained some impetus after a young woman, Brodie Panlock, killed herself after being bullied at work, and that led to criminal legislation in Victoria. Don't know if there hasn't been any talk recently of similar kind of legislation being enacted in New South Wales, but certainly with the change of government anything could happen given Adam Searle, who helped draft the Industrial Relations Commission, is likely to head that charge. After that, there was the Australian government then convened the Standing Committee on Education and Employment, looking at bullying in workplaces, and that report was delivered in 2012. And it looked at the prevalence of bullying in Australia. It looked at this idea of bullying is really about a culture. And I should say a lot of this stuff, bullying is really a form of discrimination or harassment in many ways, but without the ground that you need to prove under discrimination law. So a lot of what I'm saying holds true for discrimination as well. It looked at the adequacy of existing education and support structures to prevent and respond to workplace bullying. It looked at administrative gaps and strategies to prevent workplace bullying and evaluate it. And out of that, of course, what came were the amendments to the Workplace Relations Act and those obligations now on employers not to participate in bullying. I guess I think that report's very good for anyone to read, particularly in terms of the extent of bullying in Australia. What the Standing Committee did was set out data showing that around 7% of the Australian workers had been bullied at some time during the last 6 months before they were surveyed, and 3.5% of them, so half I guess, had been experienced bullying for longer than a 6-month period. So you can imagine, in fact the Productivity Commission said that led to significant decreases in productivity. In terms of our profession, you may or may not be aware that it's much higher. It's like 1 in 5. And some put it as high as 50% amongst female lawyers. There's a range of issues, and I should say Ingmar and I will be putting together a joint paper which we'll publish at some point, so all of this will be in there. A range of reasons for that. Some of it is, I think, what we do, the long and the short of it is what we do is institutionalise violence. And so we have a very high hurdle for how we expect to be treated and treat each other in many ways. Is that a good thing? Well, our rates of burnout are much higher. You only have to look at things like the Tristram Jepson Foundation and things like that have been set up to address the issues of mental health in the profession to realise that it's a significant issue for us. It is about bullying conduct becomes, based on unreasonable expectations, I guess, become normalised in certain cultures. So all of this legislation and any policies and procedures that are put in place are really talking about cultural change. So that's one of the things I want to talk about in terms of some of the case law, which is that some large organisations have used their policies and procedures as part of an overall strategy to affect cultural change. And you may or may not be aware of a recent case, I think it's Luke Caldwell, and I'll find it for you. Sorry? It's Luke Caldwell and Sydney International Container Terminals, and that's literally handed down on the 9th of February, so it's a fairly recent one. In that case is interesting for a couple of reasons. One is it talks about what does the connection have to be between the workplace and the conduct for it to actually still be actionable as conduct in the workplace, and I'll tell you why that was an issue in this case. In that case it was held that it was. But it's also interesting because the employers in that case had taken a very deliberate approach to reconfiguring all of their policies and procedures in the context of trying to attract more women into that workforce. There, of course, it's the wharfies. And they recognised that harassment in the workplace was one of the reasons why women don't work there, and so that they really needed to ramp up their efforts and effect cultural change by taking a very hard line on it. And indeed, you may well have seen this, those of you who subscribe to Workplace Express, but when they were contacted about the outcome of this case, which was an unfair dismissal case, they talked about how they'd been proactive in recruiting women, and they were proud of the increasing ratio of women to men, and that the policies and procedures were about helping them create an environment where that was possible. So, policies and procedures are not just about limiting illegal liability, although that will happen, but it's about an idea of what kind of workplace is it that you want to create. Do you want to work within? So that case was an interesting one. It was, as I said, an unfair dismissal. The applicant in that case had gone out after work, had 6 beers, as you do, went home, had a few more beers, called a mate, had a mate who was a girl, send him a pornographic video of a woman masturbating. He thought that was grand. He emailed it round to everyone. Some question about whether he meant to do that or not. So he wasn't at work. It was way after work. He was at home. He emailed it, he sent it round via Facebook. So it was only to his friends, only to people who had agreed to be his friend on Facebook. And there is some question about whether he meant to do it or not, because he did send a later message saying, "I'm sorry, I didn't mean to send it to you all." Having said that, you could read that both ways, given he probably knew they were going to take a fairly hard line to the policy. Of course, a complaint was made, or perhaps not of course, but a complaint was made, and he was sacked as a result of the investigation. Another interesting part of this case was whether it was appropriate for them to conduct an investigation in circumstances where there wasn't a formal complaint. That's a very interesting question. Do people have views on that around the room? I'm seeing a nod up the back, or it could just be I'm nodding off. What do you do if someone comes to you in your firm and says, a barrister's sexually harassing me, but I don't want you to do anything about it?
We often get HR people calling up and saying, I haven't got a formal complaint, but what would that
Yeah.
You've got a positive duty.
Yeah.
Whether it's duty of care of the common law or work of safety.
Yeah. I'm skating ahead a bit, but there are also a number of provisions in the discrimination laws that make individuals liable where they aid or permit discrimination to occur, breaches of the Act. They're very, very rarely used, or there isn't much case law on them, but they have huge potential to join HR managers who are told things like that and do nothing about it, managers who are told things like that and do nothing about it. So, yes.
Just while you're talking about the Fair Work Commission,
Yep.
remember that famous Frank Raffaele decision about the nationwide news briefly said when I think got pissed at lunchtime, breached the policy, got reinstated. A couple of years ago, you got that Stutzel and Lynn Fox case about Facebook. With cases like the Caldwell coming up, do you see that the Commission's becoming less tolerant of behaviour that's contrary to policies, or is it just like a withdrawal?
I think in general that would be my observation, but what do you think, Ingmar? Are you going to talk afterwards? He's going to.
But also because they can't hear me online unless you're standing in front of the microphone, so I will deal with that though.
Okay. Yes, certainly my impression is that there's a growing lack of tolerance, but that's partly to do with implementation, which I'm going to come to, because it's all very well to have policies and procedures, as they said in Caton, that, or if you don't, that's kind of the starting point. But if you don't implement them, then how do you rely upon reasonable steps or anything else? And certainly this case, the Caldwell case, is one of those ones where they had a very clear policy, they'd clearly implemented it, they'd relied upon it, they told people they would be disciplined on the basis of it, and that's exactly what happened.
Just on that point, Kellie, how did they deal with the effective break between being at work and many hours later?
Yeah, I was just coming to that, about how did the Commission deal with it. I'll read you out the specific book. So this is the question now coming to, how do you call it still in the workplace or connected with work, depending upon the definition under the Fair Work Act or the Discrimination Acts. And what Commissioner Kenner said in this case, I'll perhaps just read out the quote. What was put as what I accept is a real contestable issue regarding the dismissal is that this was out of work conduct, not involving any work-related facilities, so he didn't use the computer at work, he used his own, and involving the applicant and employees of the respondent who had self-selected to be Facebook friends. And in relation to conduct among whom the applicant has forcefully submitted is no proper business of the employer under the terms of its policies or otherwise. Here, however, there is nothing to indicate that there was anything other than the cornerstone of the employment relationship which led to the applicant having 20 work colleagues as his Facebook friends and sending the video to 19 of them by messenger. Employment by the respondent of the applicant and the 19 employees is the relevant nexus here, it appears, and their being Facebook friends stemmed only from that employment. Approached another way, if there was any nexus other than those individuals that were all employees of the respondent, there is no evidence of it. So I guess what Commissioner McKenna's saying in that is that one of the things that can see, the reason why you have policies like this and the reason why they have a reach beyond the workplace is that they are fundamentally about relationships that can be very badly affected in the workplace and impact on productivity. And in this case, the applicant didn't put on any evidence to say, well, actually, I'd met all of those people at the rowing club or I had children at school together and we routinely see each other in other places. It was very much a product of that workplace relationship. I suspect even if he had been able to put on that kind of evidence, he still would have had a hard time in this case because it is about whether the relationship is going to be affected and if people are doing something, whether inside or outside of work, that affects that relationship. And I'll talk a bit about Vergara, which is one of the leading discrimination cases, in a moment. So in order to have effective policies and procedures, what an organisation needs to do is really clearly identify the risks, which should include an audit of the workplace. This really goes across the board for discrimination, harassment, bullying, but also any work health safety type issues, of which bullying and harassment is one in terms of psychiatric injuries, but obviously if you're advising employers who have heavy machinery and things, then this takes on a whole other meaning and context and what an audit of the workplace actually should be. Assess the nature and extent of the risks and determine the likelihood or probability and severity and the appropriateness of control measures, and decide what steps you're going to take to control each of those. So those are really requirements which find a grounding in the Work Health Safety Act as well as anything else. So one of the important things, I guess, to recognise is that there's no one size fits all, and that's because, of course, there's big employers, small employers. Any policies, and the Australian Human Rights Commission has some fine policies and procedures that you can look at online, and I'll give the web references in the paper. But you cannot just download those policies and it will work for every organisation. They really have to be tailored depending upon how big you are, what resources you've got access to, what kind of work you do, and who are the people going to be primarily responsible. Obviously, large organisations have more choices about where that responsibility might be located. And sometimes the legislation will say it's located in particular places too. So, as I said earlier, there needs to not be a disconnect between what's actually in the legislation and what's in the policy. They need to mirror each other. Okay, so in terms of discrimination law and what good policy should contain, obviously by reference to the legislation, and I'm already running over time, so my apologies, it should give a clear definition of the people that are covered. And what that means is, in discrimination law, giving a clear definition of each of the grounds of discrimination, so people are clear about who can claim, because if you don't fit a ground, you don't even go on to the next question about whether it's direct or indirect discrimination. And then a clear description of the discrimination, both direct and indirect, and there's now about 4 tests. There used to be, direct discrimination, calling someone a black bastard, the unfavourable treatment because of the belonging to a different race, so that you belong to the category, treated unfairly, and there's a connection between the two. And there's indirect discrimination, which is everyone's treated the same, but the condition or requirement has a differential impact depending upon your sex or race or so on. So clear definitions is the first thing. People should know what they need to do if they've got a problem. So complaints handling strategy. Again, that'll be different for every organisation, and large organisations will have different strategies to smaller ones. There should be a clear implementation strategy, and that will include making sure that everyone has access to the policies and procedures in some form or other. They know where to find them, they know who to ask questions about if they don't understand them, they know what steps to take, they know where to go, and training so that people get to ask those questions in a structured environment. A lot of that stuff is done online. I know that FCB does a lot of that stuff. You've got a computer arm, don't you, that an IT arm that provides services of that kind for employers. And certainly the proof is in the pudding that in cases such as McAllister and SEQ Aboriginal Corporation, where they sought to rely upon, again, the defence that they took all reasonable steps, that they had carried out each of those things. They had an appropriate complaints handling process. They had a clear set of policies and procedures. They had a person in the organisation who would go and explain to people what they meant in regular intervals. They had employees attend workshops. And in this particular case, the applicant had made a complaint against someone who had already had a complaint against them before. And you would have thought that would make it more difficult to rely on the defence in this case. But in fact, it made it easier because they had promptly investigated the earlier complaint. They had given him clear disciplinary warnings about how it wouldn't be tolerated anymore, and first and final type of warning, that it would be treated seriously and he would be dismissed if they had any wind of it again. And they also put in place, and I think this is a an interesting thing to think about in terms of what you might include in your policies and procedures is that they thought about how he did his work and they placed certain restrictions on his dealings with certain people. So that's also something to keep in mind, so that they could keep track of that. And in addition, they investigated the complaint of the applicant in this case swiftly. And so the court held clearly all of the above steps taken by the Aboriginal Legal Service were appropriate and specifically targeted at sexual harassment generally, or specifically for Mr. Lamb after the initial complaint was raised. And this is the important bit, I guess, from the case law. While I accept that they could have perhaps done more, that's not the test in the relevant provision. It's simply that the employer must take all reasonable steps to prevent the harassment complained of from occurring. So they don't have to take every step possible, is the bottom line. There's a multitude of examples of cases in which people have tried to rely on policies and been unsuccessful. I'll leave those to you to read in the paper at your leisure. One of the things that I did want to touch on is raised in this forum is this idea of how far does the workplace go. And as I said in one of the leading decision in the discrimination jurisdiction is the decision of Vergara. And in that case, there were 5 different instances of sexual harassment alleged, and one of them occurred at the pub across the road. And I think the reasoning of the majority of the full court of the federal court was certainly correct in that they held it was part of the employment, and they held it was part of the employment because in this case what happened was the manager came into the room, turned off the lights and started trying to manhandle the woman involved. She said, "I am not ready to finish work. I don't want to talk about. Your attentions are not welcome here," kind of thing. And in the hopes of managing the situation, particularly in a context where there were more people around, she agreed to go across the road to talk about his attentions towards her and the fact that she didn't want them. So on that basis, the full court held that it was a continuation, because it was a continuation of a discussion that started effectively in the workplace. The minority decision, I think it is, of Justice White, leaves a lot to be desired, in my view, in terms of an analysis of what the legislation requires to do, what meaning is to be given to the term in connection with the workplace, which is the term in the Act. And his dissenting decision basically says that he went there in furtherance of his own sexual goals, if you like, and there was nothing to do with work involved in that. And so it couldn't be considered to be in the workplace in that context. My view of that is that, with the greatest of respect, that no one could be held liable in that situation. And it certainly ignores the history of the reasons why this kind of law was introduced. And one of the reasons, there's of course 2 parts to the definition of sexual harassment. One is about unwelcome conduct, which requests for sexual favours and the like, of which this case Vergara was one. It's also just about sexual conduct in relation to people. But the first of that part of that definition is about power differentials. And it must certainly be an issue for anyone who supervises propositioning them as to whether they'll keep their job. Anyway. So Vergara is the leading case on that, and I would commend that to you. And in terms of what should be in policies about what constitutes the workplace, I think that's a pretty important one to make clear to employees that, according to the case law, more likely than not, things they do outside of work are going to be counted as well as anything else. Now, I note the time. I might hand over to Ingmar at this point. I just briefly did want to say something about the incorporation of terms into contracts. Nikolic is a case in which precisely that happened, where Mr Nikolic had been bullied. He relied upon their work health safety policies, which he said were incorporated into the contract via a term in his contract, which he signed before he entered employment, and he was successful on that basis, and he received damages on that basis. Of course, This is unlikely to come up very much in New South Wales at this point, given the changes to the Civil Liability Act, which means that you can't claim general damages. He was a Canberra person, for any kind of psychiatric damage of that kind. So it's unlikely to apply. But thank you very much, and I'm happy to answer questions afterwards, and I will hand over to Ingmar to talk about the work health safety aspects.
Can I join Adam and Kellie in welcoming everyone here? One of the things we wanted to do when we established this floor a couple of years ago is to do things a little differently than the bar tends to do things, and that's partly reflected in the way in which the Chambers is built, sort of much more open plan, and it's reflected in what we're doing today, this sort of CPD program, where we are engaging in a hopefully a direct way of communicating with the people we work with, the solicitors we work with. And it's reflected in the fact that we have gone one step further, and we're now apparently at the cutting edge of technology. We're live streaming as I speak, and things like this program and the paper that Kellie mentioned are again available through the website later as well. I will. Okay. All right. That's fine. I'll come to. So the paper, I think we'll finalise. It just needs a bit of tidying up in the next week, and once it's finalised, it'll be up on the same page that you'll find the CPD programs. So I'm going to be talking about the need for policies in a work health and safety context, and then using drug and alcohol policies as an example, talking about why, from an employer perspective, it's very helpful to have policies, and from that, more generally, why policies that deal with conduct outside of work can be very useful when one is dealing with a desire from an employer's point of view to govern conduct outside of work that can affect the work, and ultimately to take disciplinary action, and the importance of having policies if you want to be able to defend disciplinary action that arises out of conduct that occurs outside of work. Work health and safety. I'm conscious of the fact that we've got at least 2 members from WorkSafe New South Wales in the audience who know certainly as much as I do on this subject, so feel free to correct me, but I wasn't going to go into this in too much detail. The bottom line is that as in the areas that Kellie spoke about, with a couple of specific exceptions which I'll mention in a moment, there is no statutory requirement to have any particular policy or set of policies written down. And yet, the nature of the legislation means that every employer needs to have policies dealing with work health and safety. Why is that? Well, as I'm sure everyone in the room knows, every person conducting a business or undertaking, or PCBU in the parlance of the legislation, has a broad statutory obligation to ensure health and safety of the workers that it engages, the workers at its place of work, and a failure to comply is no small matter. It's a criminal offence, and it's a criminal offence that for a corporation can, if it gives rise to a risk of serious injury or death, carry penalties of 1.5 million or above. And so these aren't things you take lightly, and if you're going to comply with them, you need policies. Why do you need policies? Because, just as in the discrimination area, the defence that you're going to have, the primary defence you're going to have in circumstances where there's a serious injury or death in a workplace, is that you've taken reasonably practicable steps to address that risk. And it's hard to think that you could make out such a defence if you haven't actually got policies in place that both identify risks and then address them.
What is reasonably practicable, you'll find defined in section 18, but it requires just that. The identification of hazards, the identification of the harm that arises from those hazards, an identification of what the person knew or, importantly, ought to have known about how to address those risks, and the steps taken to address them. So, as I said, policies become almost obviously necessary. Now, the people that will be tending to sit in the room with you and talk to you about these policies will be people who you can, once you've explained the nature of the legislation, you can be assured will be listening very carefully to you. Because if they are directors or they are senior managers, people who make or participate in making decisions that can affect the whole or a substantial part of the business of the entity, then they have a personal duty, which if breached is a criminal offence and can give rise, in the most extreme cases, to jail time, to ensure that, again, the entity or business that they're involved in has taken all reasonable steps to ensure safety. And the test that the section refers to is an obligation of due diligence. And then the relevant section goes on to indicate what is involved in due diligence for such a person, such an officer of the business or undertaking. They have to have up-to-date knowledge of work health and safety matters. They have to ensure the business has and uses appropriate resources and processes to eliminate or minimise safety risks from the work carried out. And whilst the Act doesn't go on and say so, it almost follows as a matter of course that would mean that they have to ensure that there are safe methods of work established for any activities in the workplace which have risks associated with them of potential injury, and that they have ensured that the business has a safety management system, documentation which demonstrates how safety issues are going to be addressed. So the Act, as I said, with a couple of specific exceptions which I'm about to come to, doesn't require specific policies, but the nature of it means that you're going to necessarily going to have them. If you go to the regulations, there are business types of work which do require not policies but procedures, and Kellie explained the difference. In particular, what the Act refers to as safe work method statements, and they are in respect of electrical work on energised electrical equipment and high-risk construction work, which is then further defined to involve a range of things, including construction work which involves the risk of falling more than 2 metres, construction work which involves the movement of mobile plant and the like. There must be safe work method statements for each of those tasks. And any of you who are familiar with dealing with clients or large clients doing construction work would, I hope, be familiar with the fact that they have, and I'm hoping not that you're familiar, I'm hoping that they have safe work method statements that deal with these types of issues. The other thing I just mentioned is there are, of course, codes of practice that are published by WorkSafe New South Wales that deal with a range of issues like confined spaces, construction work, demolition work. I've got an office that looks over that corner behind you, and I've been watching the demolition work going on, and on occasion sort of shutting my eyes as the dogman stands underneath the the load as it's coming down rather than standing to one side and the like. There's codes of practice that deal with a range of things, and they are not themselves mandated as in a breach of them is a breach of the Act, yet they are used by inspectors as a guide. They will often issue improvement notices or prohibition notices by reference to them, and they are admissible in proceedings to demonstrate known risks and known ways of dealing with risks. One of the codes of practice relevant to what we're talking about today is titled How to Manage Work Health and Safety Risks. And so for anyone who is assisting employers to draft policies, that particular code of practice is a very useful one to have reference to. All right, let me zip over to just dealing with, it's always useful to have a factual example to explain the importance of these things. I'm not really sure it really needs to be driven home in this area, but the Attorney General and Tow Services is a case that got to the Court of Criminal Appeal. Almost every one of these cases is a sad case, but this one's a particularly sad case. A 15-year-old Year 10 student goes to this particular business to do a day's work experience. When he gets there, he says that he's done some welding before. And they say, oh, great, well, you can do some welding for us. And they give him a visor. It's a visor which is permanently dark, unlike the one he'd used at school. The one he'd used at school is the more modern one, which is like those sunglasses you can sometimes get that adjust to light. It's clear, except when there's bright light, and then it goes dark. So he put this visor on and found it really hard to see anything. And so after someone had checked he knew what he was doing, he was left to his own devices. He put the visor up because he couldn't see anything and kept welding. And it was only some hours later that a worker noticed that he was welding without the visor on, and by that stage he had permanent eye damage and will, I understand, for the rest of his life have great difficulty seeing. Now that was a failure at a number of different levels. Ultimately, any policy is only as good as its implementation. Here there was a policy dealing with welding, but no one had communicated it to the boy. No one had explained to him what must be done with respect to the visor. And why was that? Well, this is the other reason why policies can fail. There wasn't a policy dealing with work experience students. There just wasn't one. And so no one had a system or a procedure to how to deal with someone who comes in that situation. So they're the two areas where policies fall down. They're either not communicated, and there's no shortage of work health and safety cases where the defendants pull out fantastic policies from the back of the filing cabinet, don't assist them greatly, even in a plea of mitigation, if they've never actually been communicated. And the second area, of course, is where a policy just wasn't developed in the first place. Now, I wanted to talk a little bit about drug and alcohol policies. Let's start with the need for them. Let me just work. I just lost my spot for a minute. No, I'm almost there. I know. I'm cutting edge, not. We'd structured the paper slightly differently than we've structured the overheads, so I'm just going back to the paper. Commissioner Cambridge said in a case involving the CFMEU and Port Kembla Coal that it would seem largely unnecessary to... he acknowledged how important it is to have drug and alcohol policies in any areas involving heavy machinery, driving and so forth. But he said it would seem largely unnecessary, on the other hand, to have a workplace drug and testing regime in the case of a call centre. Which I remember reading at the time thinking, in fact, if given I'm on the other end of those calls from call centres, I'd be quite happy if the people at the other end of the phone were influenced in some way, because frankly the phone calls couldn't be any more annoying. Maybe they're slightly less annoying if the person had had a couple. But there are places where it's obviously necessary to have drug and alcohol policies, and there is disputation as to testing modalities at an industrial level, that is, not on alcohol. It's pretty clear how the way alcohol is tested, but when it comes to testing for drugs, there is quite strong views held by unions and employers on one hand and then the other as to whether it should be oral fluid testing, which tends to pick up marijuana that's been consumed very recently and does not tend to pick it up if it's been consumed in the past, versus urine testing, which is the converse. It will pick up marijuana use that's been some days old. The unions contend that the point surely should be to test for something close to impairment, and the employers are saying if you've got a chronic marijuana user, then they will be continually impaired even if they haven't smoked recently. Anyway, the point that I was going to make, carrying on from what Kellie was saying about the need for policies, was one by reference to this decision in Harbour City Ferries about the importance of having policies if you're going to defend your position. So take this particular facts example. Here you had a ferry master driving one of the ferries that are out in Sydney Harbour, and he was at home, he was suffering shoulder pain, and he smoked a marijuana cigarette. And the next morning he was phoned. He wasn't on duty the next day, but he was phoned, could you come in, because we've got someone sick. So he agrees to come in the next day, and the ferry he's driving strikes a wharf, and it's no significant damage is done, but the very striking of the wharf causes a passenger to lose balance, not really injured, but it's significant enough for it to be reported. By him, he does the reporting, and that triggers an automatic drug test, and it's a urine test, and he gets what is referred to as a positive, so to speak, and he is then dismissed. And the unfair dismissal comes before the Commission. Now, in that particular case, there was a policy, and the policy was absolutely clear. If you have any cannabis metabolites in your system, then that is a dismissible offence. The test isn't, are you impaired at the time? That just wasn't what the policy said, and there's a good reason for that. You cannot test for impairment. There's no oral fluid or urine test that can see how impaired you are. They can only test as to whether you have the cannabis metabolised in your system and that's being picked up. At first instance, the dismissal was found to be harsh. There was no evidence of impairment. There was no evidence that the marijuana cigarette he'd smoked the night before was in any way related to the incident. It was accepted that he'd smoked it because of pain. It was accepted that when the time he smoked it, he wasn't expecting to have to drive the ferry the next day. He'd been a ferry master for 17 years. A dismissal would have very harsh consequences. It's not as if there's a lot of other ferry companies around that he could work for. He was open and cooperative with the investigation. There was a series of things that the Commissioner took into account. It was then appealed. And in the appeal bench, the submission put to the appeal bench was in what I'd call the Alan Jones factor. That is, an employer does not want to have to explain to anyone, including radio commentators, why it is that they have to employ someone who was tested positive for cannabis whilst driving a public transport vehicle. They shouldn't have to do so. But the reason the full bench overturned the decision was because there was a policy, and the policy was one known to him. He knew when he took that shift that if he was tested, he would be picked up, and he knew that that was a dismissible offence. So a zero tolerance policy that had been communicated to him was the basis upon which that dismissal was upheld, and there have been a series of decisions since which have carried through the same concept. That is, if you have a zero tolerance policy, then someone who knowingly breaches it, I mean obviously an unknown breach is a different category, but knowing breach of a zero tolerance policy is sufficient. And so the most recent authority involving, in fact, another another driver of a ship, this time an actual ship, not a ferry, the Farstad shipping case involving Captain Rust. He drank 10 schooners the night before he went on duty. Again, he'd been called up relatively late, but I think by the time he was drinking the schooners, he knew he was on duty the next day. And he was still, he wasn't 0.05, he was slightly under 0.05 the next morning at 6:30 when they did a random alcohol test. Again, at first instance, he was reinstated. Harshness, 61 years of age, very hard to get another job. There was some reasons why he'd been drinking that were actually related to a previous work incident that had caused him anxiety and stress that were accepted by the court. But the full bench again overturned it and said, no. He knew there was a company policy, it was absolutely clear, and the policy required him to self-report the next day if he thought he might still be influenced by alcohol. He didn't do that, and that meant that they could dismiss him and zero tolerance policy could be upheld. So if we get to this idea of conduct outside work and where's the line, we are seeing, to answer the question earlier, we are seeing a series of commission decisions which say, look, if the employer has considered this, has a policy on it, and that policy is then knowingly breached, then the employer can dismiss. Now, for my part, I'm thinking, yes, but there must be a limit as to what the employer can have a policy on. There's got to be a limit. I mean, if the policy is, to take an example, you shall never drink alcohol, ever, and they pick up that you have drunk alcohol on a Saturday before you came to work on the following Monday and you had 2 drinks, is that a reasonable, I mean, they might have such a policy and you might know about it, but is that a reasonable step? And I'd like to think you get to a point where there's some points of what you do in your private life that the employer can't influence. But the commission approach seems to be the employer can legitimately take action if you've breached a policy, the purpose of which is in some way related to your work. And so if, for example, and there is a series of cases involving social media posts, where you've posted things and you've done so in a way that can associate you with that employer, and that then affects the employer's reputation, then that social media post is one that can lead you to be in breach of a policy which could legitimately lead to disciplinary action. And the same thing, and Kellie and I, when we were talking about this, not that we've actually spoken yet about this one, I'm about to mention it, we started talking about this topic and we actually spent the entire hour talking about sex in the workplace and at what point can the employer have a policy about it, because of course, the Barnaby Joyce story was live at that moment, and the government had made the decision that it would ban all sex between politicians and their staff, and we were like, well, can employers do that? Is that something they can do? It's what we know is what private industry is doing at the moment is saying we're not going to ban you doing it, but there's got to be disclosure. But even then, is that enough? Like if the managing director discloses that they're having a relationship with the 18-year-old new temp, is it okay? So, well, you've disclosed it. That's fine. Go ahead. Or do you actually have a duty to do something about that? And I was thinking about that today because there was a story on the Guardian website about Monica Lewinsky saying, look, in retrospect, I mean, yes, there was consent, but there was consent in a circumstance where he was like the most powerful man in the world and I was a 22-year-old who didn't know anything about anything. And in retrospect, wasn't there something wrong about that something should have been done? It does raise questions about exactly how far the policy can go. But to answer the question earlier, I think the Commission will tend to take a view that provided the employer can rationally justify the policy as one that is protecting the employer or employees, other employees, even if it's conduct in private life, the Facebook posts sent when drunk to a whole group of friends who happen to all be other employees, then the Commission will uphold disciplinary action that results from that. Now, I'm conscious of the time. The paper will be dealing with, amongst other things, domestic violence, which I spent some time today catching up on. It's quite fascinating, and the latest word, for me anyway, is the Commission statement that's came out late last year, which has produced a draft clause which has dealt with a number of the issues. Possibly the most significant one in my mind is confidentiality, because it must be such a difficult thing. You've got, on the one hand, you're creating a right for people to take leave, and in some workplaces it's paid leave, and on the other hand, people are unlikely to exercise that, and their work might continue to suffer and so forth if you don't have a clear process by which they know that they can seek the leave on an entirely confidential basis. But as I said, the paper will deal with that. So I should, noting the time, wind up. But as Adam said, both Kellie and I are happy if there's anything any thoughts that we've sparked, issues that you think you'd like to say something more about. Nathan is about to turn on a microphone, which will mean that you can be heard and recorded without having to come up here, and we'll do our best to answer or comment on any thoughts that you have. Thank you. I don't know whether we should stay here, but you take the role, Adam.
Are there any questions for Ingmar or Kellie? No? Yes?
I'm always interested in how you deal within a policy, particularly about discrimination and harassment, the issue of confidentiality, because oftentimes I see policies from my employer clients which say your right to confidentiality will be maintained at all times, which actually is often quite difficult, particularly if there is to be disciplinary action that follows, because, you know, the accused is entitled to know whatever's been said about him or her, and there's at least some Fair Work decisions which say that you don't offer the proper procedural fairness by not telling them about the complaints. So in terms of drafting policies, we sort of take a middle line where we say protect confidentiality to the first extent possible, and sort of set out that tension in the policy. Is that the right thing to do, do you think?
Oh, I think absolutely. And I think one of the things that will be in the paper is... one of the things that will be in the paper is a bit of a talk about investigations, when to do them, when not to do them, the choices that you make around that, whether liability will flow if you do a botched investigation or not. And there's a whole range of interesting case law that's happening at the moment, including an appeal to the High Court in a matter called Govia, that'll be in the paper as well, about whether if there's a botched investigation, whether they can distinguish Page and New South Wales. And you remember Page in New South Wales was about they had an obligation to report and investigate sexual misconduct, and Mr Page made allegations. He had a common law right. There was a duty of care not to psychiatrically damage him. So in terms of investigations, absolutely, I think you cannot get over the procedural fairness hurdle, which is crucial and should be in every policy about if we do an investigation, people will be given procedural fairness. What does that mean? You'll know what the allegation is and you'll be able to give your point of view. And there's no way that you can necessarily protect confidentiality as against the complainant and the perpetrator, if I can put it that way, and sometimes not even against witnesses. I've done various kinds of investigations at, various ends of town, and one of the things you can do is when you do investigation reports, is you're very careful about how you handle that information. That's kind of a talk on its own. But I agree with you that you can't protect people's confidentiality. You can only do it to the furthest extent possible, which absolutely means is it doesn't become common fodder for everyone to talk about at the water cooler who's made complaint against who and whether so-and-so does that routinely or not. And indeed there should be information in there about the dangers of defamation. And we've seen that happen with Geoffrey Rush, who's brought the defamation proceedings in what's happening with him at the moment. So, yes, I agree with you about that. Do you have something you want to say about that?
No, I was going to ask you a question about it, but I didn't want to take other people's question time in case there was...
I've got a question, but you go first.
No, well, just following on from that, Kellie, the subject that you and I discussed, which really rises out of Leonie's question, is what do you say, what should the policy require you to say when to take an example, the young woman comes to you as the HR manager and says, look, my boss, who I like, who's a lovely guy. I don't want to get into any trouble at all, and so I don't want you to get him into any trouble at all, and I certainly don't want him to know that I'm talking to you about this, but every time I lean forward, he stares at my breasts in a way that makes me feel uncomfortable. What should the policy say about how to deal with that situation? The person says, whatever you do, don't tell him that I've spoken to you about it.
Oh, my view is the policy should state really clearly that where people raise any issue that's a potential breach of the policy is you have an obligation to do something about it, and that there are victimisation provisions which theoretically are supposed to stop people treating you poorly because you've made a complaint. So you don't actually have to prove that your complaint had any merit, but if you make a complaint and you are absolutely treated poorly afterwards, and you can prove that, that's victimisation under state and federal legislation. So,
and I think it follows from what you said, that the HR manager says, look, I can't not deal with this situation that you've raised with me. I can't not raise it with him, and I can't not tell him that you're the one who's raised it with me. That whether they like it or not, that's, I think from what you're saying, that's really what's required, isn't it?
Yeah, it is. Yeah, I mean, in a perfect world, where you have really good training, people would feel empowered to be able to say that themselves. When you do X, makes me feel uncomfortable, please don't do it. And in general, if you do that, most young people find that very hard, but in general, if you do that, people will pull their heads in.
One tactic that businesses do in a scenario like that, rather than release the identity of the non-complainant, is to run a generic update and refresher. And it's time to update you all, not to look at each other's chests when you get a one-on-one.
Or packages.
That's not ideal, but that's commonly what our clients tell us they do. I just like a different question, Kellie and Ingmar. I seem to recall a line of authority. I can't remember the case name, but I'm sure there was a case involving Qantas and Deputy President Drake, where Drake found a dismissal to be unfair because the policy itself went too far to prohibit conduct that the employer had no right to seek to address outside the work. I think it was a fraternisation policy, if my vague and ageing memory serves me right. I thought there was a line of authority where the Commission could say if the policy is unfair, the dismissal isn't safe.
Yeah, I might not be thinking of the same case. There was a case involving a Qantas flight attendant, and I think either a female flight attendant, and either another male flight attendant or perhaps a pilot, and she had got very drunk and woken up the next day in an overseas port and was convinced that she had had sex with the co-worker in circumstances where she was not confident she'd given consent, and he said it was all consensual. But Qantas couldn't prove consent or otherwise, but they nevertheless dismissed him on the basis that it was a breach of policy. And Deputy President Drake took a view. Now, what my recollection doesn't extend to whether they actually had a clear policy, a zero tolerance policy, or it was some sort of broader policy, because but in any event, it predates the Tom's case that I was talking about. I have always had a view that an unreasonable policy is one that shouldn't be allowed to be relied upon to justify a dismissal. But the Commission has, in Tom's and later cases, taken a view that provided the policy can be rationally justified by the employer, it's not their task to work out how reasonable it is. I think, as I said, the line would be if you have a policy which is entirely unreasonable and can't be justified, then a breach of it can't justify a dismissal. But I think in a case like that, an employer could, Qantas could justify a zero tolerance approach and so forth. And on current authority, a breach of that would then trigger disciplinary action which wouldn't be overturned.
There is a really interesting debate going on, particularly in social media, where often employers have policies about, don't say stuff about us on your Facebook, Twitter account, etc.
Yeah.
But then what happens if an employee who is associated uses his or her LinkedIn account or something that's associated with work starts sprouting far-right views or support for Donald Trump or support for the NRA? There's some pretty interesting.
Yeah, and that's, as I said, that's where you get this line. You can do things in your own time, but the employer probably can have a policy which prevents you doing it in your own time if you do it in a way that associates in the public view the employer, with you. But there will be, at the very least, there will be, if you get into the political sphere, questions of the implied constitutional right to political free speech, which is where this, it hasn't gone up, but I think it will get there, this question of exactly how far can you go. And there was a case involving an officer of the reserves, I think, who had very strong religious views and expressed those, and his strong religious views manifested itself in views about homosexuality which were not consistent with the views of the Defence Forces, and they directed him not to express those views, and he expressed them anyway. And that, at a federal court level, was held to be that the Defence Force was capable of disciplining him for expressing those views because he was doing so in a way that associated himself with being a reserve in the army. But it's one of those free speech issues which is sort of watch this space, I think.
I just want to say one other thing about the if someone comes to you and they don't want to be identified kind of scenario, which is to reiterate what I said before about 106 of the Sex Discrimination Act makes people individually liable if they know something's going on, and if an HR manager gets that information, does nothing about it, then down the track and there's a serious psychiatric injury, then they are one of the people who can be personally joined. And the other thing to say about that Qantas case, the approach taken by Drake seems to be consistent with that decision of SEQ and the Aboriginal Corporation, which is there can be a middle ground whereby you place certain restrictions on people and how they'll conduct themselves at work after something like that happens. So it's something to think about.
Well, thank you, everyone. That concludes tonight's CPD. Can I invite you all to hang around for a glass of wine and some canapes before you head back to the office? Or perhaps home. We'll see you shortly. Thank you.